the Master of the Rolls, Lord Justice Coulson and Lord Justice Nugee, in the matter of Britvic PLC, the Britvic Pensions Ltd and another, case number A3 2020 0316, Thursday, 13th of May 2021.
Mr. Bland.
My Lord, good morning. We are still very much on track, as I suggested yesterday, to finish our submissions in time for a mid-morning break and still allow Mr. Chew and Mr. Short at least the time that was allocated in our indicative timetable. So we're doing pretty well, if I may say so. Just in terms of the timing, I'm aiming to finish in good time for a break before 12, which I think is about the time we took a break yesterday, sometime between 11:30 and 12. In terms of my remaining submissions, a fair amount of streamlining has been done overnight. I'm not planning to develop our submissions on grounds 2 to 5 of this appeal, unless obviously you invite me to do so. They're set out in our skeleton, and like most, if not all, of my submissions, they're not going to improve with repetition. So we'll simply rely on what's in our skeleton argument for those points. What I am going to seek to address is four key areas. The first is why we say the natural and ordinary meaning of the wording in Rule C.2 is not what the claimant says it is. The second is why a more reasonable and practical effect is the result of our construction. And that will include a consideration of the LPI legislation based on the claimant's interpretation of it, which we say isn't right, but even if it is, that doesn't help them. The third area is the documentary background, which we say should push the court further in the direction of our construction. And to pick up the point in a question from my Lord Justice Coulson yesterday, that it works, we say, either on the basis of standard construction or, if necessary, a corrective construction basis. We say, insofar that as there is a mistake, it's clear what the mistake was and what needs to be done to correct it. And finally, time permitting, I'll address the point raised in our respondent's notice, which is in a sense why we say the claimant is wrong in its interpretation of the LPI legislation, which again we say pushes us yet further towards our construction. Before coming to those key topics, though, may I deal very briefly with a criticism raised by Mr. Short in his skeleton argument of the judge for declining to construe pre-2003 instruments. Now we accept, as the judge did, that predecessor provisions are clearly part of the admissible background, but in this case, they were provisions in a different scheme, so we are yet further removed from the principles from Lady Justice Arden in the Stemmer case. It's not simply re-adoption of a rule by the same scheme, it's a different scheme entirely. We say the circumstances in late 2002 and early 2003 were very particular in respect of the transfer transaction that I'm going to come to in a little while. So we say little weight could realistically be put on the construction of, say, the 1996 BAS rules. Plus, as you'll have seen from our skeleton argument, there was simply no evidence put before the court below, or indeed here, as to what the factual circumstances were in 1996. What we do have is the legislative background, which is, for all material purposes, the same as it was in 2003, which, for reasons I'm going to come to, we say supports our construction rather more than Mr. Short's. And in any event, none of this could have had any effect on executive scheme members because, as we know, there was no equivalent power in their scheme to alter the pension increase rate.
Don't you rely on? Sorry, I think we're getting a bit of feedback, but it may be my fault. Don't you? I mean, that's a point you rely on.
Yes.
So, and very strongly. So, in a sense, you do want us to go back before 2003 to say, well, the executive plan members did not have this power before, and the staff plan did, and so that helps me.
My Lord, yes. But the position of the executive scheme has never been in dispute. That's been agreed by all parties throughout. But as a matter of principle, yes. That must be right. May I come to the first of my main topics, which is natural and ordinary meaning. Your Lordships will be more than familiar with the principles in play here, and doubtless considerably more familiar than I am. But it must be the case that one recognises that the natural and ordinary meaning of wording of an English phrase can be difficult to ascertain. We've referred in our skeleton argument to Lord Hoffman's, one might think slightly dated example in the Charter reinsurance case. Husband asking wife, how much did you pay for a new dress? She bought it on credit. Obviously the anticipated answer was, what was the price of it, rather than how much had in fact already been paid, to which the answer would have been nothing. We've given another, perhaps modernised version of it in our skeleton argument at paragraph 33. I'm not going to take you through that again, but I simply invite you to have a look at it when deliberating this matter. I see various other examples are given by Lord Hoffman in his Language and Lawyers article, which I hope has found its way to you overnight. And all of these are simply illustrations of the care with which one needs to analyse the meaning of words. A literal approach often will not work to get to the intended meaning, even if at first glance the words used appear to be unambiguous. On a little further thought, it is often the case that they are not. And the same goes for words that at first glance appear to be all-encompassing, such as the words relied on by Mr. Short in this case. Words, phrases starting with any other, and fill in the blank. We've given, again in our skeleton, and I won't take you through it in detail, the example, it's at paragraph 34A of our skeleton argument, from the Laconian confidence case. Mr. Justice Ricks, as he then was, there was an off-hire clause in a time charter. There was a list of potential causes that would prevent the full working of the ship, and the phrase ended or any other cause, and that was construed as having a restricted meaning. One of the principal reasons, perhaps it would be helpful to take you to the case, is tab 6 in the authorities bundle. It starts at page 139, and the relevant passage for my purposes is towards the top of page 153. And Mr. Justice Ricks, it's the first full paragraph at the top of the page, says this: those comments bring me back to consider the phrase, quote, any other cause in light of the authorities. In my judgment, it is well established that those words, in the absence of, quote, whatsoever, should be construed either ejustem generis or at any rate in some limited way reflecting the general context of the Charter and clause. And then a few lines down. It is to my mind natural to conclude that the unamended words any other cause, i.e. unamended insofar as they don't say any other cause whatsoever, do not cover an entirely extraneous cause. The next case we've relied on and set out in our the reference in our skeleton is the Sentient case. It's tab 8 in the authorities bundle. And in this case, the court was dealing with a clause that did include the word whatsoever. A payment clause said that it would not be affected by a number of identified events or by any other matter whatsoever. And that was held on its proper construction to have a limited meaning. It didn't mean what was contended, and it did not exclude a purchaser's right of set-off. And the relevant passages, I'm not proposing to read them out unless you invite me to the very bottom of 172 and over to the top of 173 in the authorities bundle numbering, and they're sidelined.
But is it really the same as to say to limit any other cause, for example, to particular types of cause, ejustem generis, and to limit the words any other rate decided by the employer to a rate that goes one way? I mean, that's really rather a different and more what should we say, more barbaric form of construction. I can put
Well, I wouldn't quite put it like that myself, my lord, for obvious reasons. Clearly, I can't say that the facts of this case are on all fours with the facts of any of these other cases. But in terms of the principle, what I do say is it does lead one to the conclusion, and it supports the conclusion, that the claimant's construction, Mr. Short's construction, which essentially is any other rate whatsoever, is not supported by the language of this particular rule.
Do you say, Mr. Brown, that this is an ASTM generous case, which is what those two cases were?
My lord, I do.
What's the generous? What's the tribe, to use the word used in the BSE case?
The tribe is the well, it's the context of the transaction, I think, is the most I can say.
But, I mean, the classic type of ASTM generous case is A, B, C, D, or other. And you take from A, B, and C, but what we're talking about is things of a particular type, and other is limited in that way. It's difficult doing an ASTM generous construction. You've only got A or other, because it's quite difficult to identify just from A what the generous is.
Well,
but you have to make an attempt to try if you're going to say it's an ASTM generous case.
my lord, can I take you? May I take you to the third case?
Yes.
Was an argument which may assist on this. It's the very first tab in the authorities bundle, and if I may come back to this point a little later as well. And it's Stagline and Foscolo Mango case, and I don't think I have time to take you to the facts, amusing as they are. It involved stokers on a ship who were too hungover to do their jobs properly, so some engineers got stuck on the ship rather longer than had been anticipated and ended up in the wrong place. But the point really comes out of the headnote, I think, and here the phrase was an A or other type formulation. It was, if one looks at the very first paragraph, it was for bunkering or other purposes. And in context, other purposes must be construed. It was held as meaning the calling having relation to the contract voyage. It's the point being here, context. Perhaps context is not all, but context is a significant part. And in the context of the Stagline case, the context led to limited construction of other purposes. And by analogy, we say the same applies here in the context, and the context includes the various matters that we've touched on yesterday. The context, we say, pushes one towards a more limited construction, and certainly it does not support the any other rate whatsoever construction that my learned friend seeks to put on it. So I come to the wording in this case, with which I'm sure you're all familiar by now. Rate of increase is, I paraphrase, what we're calling the default rate of 5% LPI, or any other rate decided by the principal employer. And we say this: if the intention, as the claimants say it was to mean any rate whatsoever, why, one might ask, does the clause not say so, as the reasoning of the court in the Laconian competence case? If one refers back to Lord Justice Evans' judgment in BOC, if the intention was that the claimant would retain an absolute discretion as to what the rate should be, again, why not just say so? It wouldn't have been difficult to formulate suitable wording. But the fact you don't have any such wording, we say, to adopt Lord Justice Evans' phraseology, is eloquent. And if, as the claimant contends, it had absolute discretion to decide the increase rate, lower or higher, we say that sits rather oddly, a point I think my Lord Justice Nugee touched on yesterday, it sits rather oddly with the fact that you do have a precisely defined default rate, RPI, as at the 31st of May, not even the statutory reference date with a 5% cap. Now I know my learned friend says, and I may say again, well, on his construction, having a default rate achieves something, because it achieves something meaningful in process terms, but because the default rate is applicable unless and until the claimant decides otherwise. But in my submission, in reality, there would be no difficulty at all for the claimant simply to specify a rate once a year, or indeed on the claimant's case on one of the subsidiary questions, stating a rate once in a while, that rate then applying until it changed its mind again. So where all of this leaves us in my submission is that the natural and ordinary meaning of this wording in Rule C.2 is not that the claimant has a power to choose any rate whatsoever other than the default rate of RPI capped at 5%. I come to my second further submission, which is reasonable and practical effect. One asks, if the rule doesn't give the claimant an absolute discretion, what does it do? Now, there are three main points here. The first is what we've called our two-stage mechanism, which was accepted by the judge, which we say makes more practical sense. The second is construing the rule as a whole, and we say our construction fits better with the scheme as a whole. And the third brings in the legislative background to some extent, which is, and our submission in short is that our construction fits better with the LPI legislation, even assuming that the claimant's interpretation of that legislation is correct, which we say it isn't. The first two of those in my submission are dealt with sufficiently in our skeleton argument. It's paragraphs 38 and following. Again, I invite you to look at those again when deliberating this matter. And I don't think they're going to improve by me repeating them now. So I'm going to move to the third point, which is the LPI legislation. And I stress that at this point of the argument, we are still concerned with the reasonable and practical effect point. I'll come to the point raised in our respondent's notice in due course, time allowing. So for now, we assume, wrongly we say, but we assume that the claimant's interpretation of the LPI legislation is correct. And there is no issue, it seems, Mr. Short accepted this yesterday, that the objective observer would have been aware of the legislative background. And this point goes for 96 as much as it does for 2003 and 2007. In any event, the cases are clear. It is coincidence that the three cases we've selected were decided by members of this court at first instance. The Spencer case, I'm not going to take you to any of these, but for your note, it's tab 18 of the authorities bundle, paragraph 73, Mr. Justice Voss, as he then was, deals with the general point of legislative background being an admissible and relevant factor. Sterling Insurance, tab 23, paragraphs 30 to 32, Mr. Justice Nugee, as he then was. This deals with the Pensions Act 95 in particular, in that case section 67. And then the Carr and I think it's Tales is the right pronunciation. Again, Mr. Justice Nugee, tab 30, paragraph 63 to 65, specifically dealing with section 51 of the Pensions Act 95. So focusing down as the cases progress, we get to the point where section 51 is a relevant background matter. Section 51 of the Pensions Act 95, as at 31st of January 2003, is in the authorities bundle at tab 36. Mr. Short took you to it yesterday. I think he took you to the 96 version, the previous tab, but if I can take you to the version at tab 36. As far as I'm aware, there are no material differences between the two versions, and indeed no material amendments to these provisions later in 2003. The structure will probably be familiar to all of you by now, but just to touch on it briefly. Section 51 deals with annual increases in rate of pension, as pensions in payment rather than revaluation and deferment. Subsection 1 tells us to which pensions this section applies, and there is a route out of the Section 51 regime. If one looks at subsection 1b, one of the conditions is, apart from this section, the annual rate of the pension would not be increased each year by at least the appropriate percentage of that rate. So if one had, for example, a rule providing for 5% fixed annual increases, as a number of schemes at the relevant time did, one wouldn't be in the Section 51 regime at all. But for our purposes, we are in this regime. So it's subsections 2 and 3 are our key focus. Where subsection 2 applied, the pension had to be increased each year by the appropriate percentage. This is the statutory rate that overrides scheme rules where it applies. The appropriate percentage is defined in section 54, which, insofar as necessary, it's in this same tab as at the same date, and it is defined by reference to the revaluation percentage set each year by the Secretary of State's order, and as at 2003, it had always been RPI for the year to the 30th of September, with a 5% cap. We know the cap was changed to 2.5% in 2005, and the inflationary measure was changed to CPI in 2011, but going back to our objective observer in 2003, there's no way that anyone could have known that at that time. And I invite you to note at this stage, because this will be of some importance, this scheme had a 1st of October increase date. So the statutory rate, if it applied under the overriding provisions of 51.2, would have had to be measured as against RPI to the 30th of September of the previous year. So the figure would have been almost exactly a year out of date, as it were, because the RPI figures for the year to the 30th of September obviously wouldn't have been available immediately the next date for the increase to be applied, even if the trustees could have done the administrative process in a day. Section 51.3 then is the exemption from 51.2, and it disapplies 51.2 in certain circumstances. Subsection 2 does not apply to a pension under an occupational pension scheme if the rules of the scheme require the annual rate of the pension, little b needn't concern us for now, the annual rate of the pension to be increased at intervals of not more than 12 months, so it had to be at least annually, by at least the relevant percentage. And section 51.4, just below, defined the relevant percentage as RPI with a 5% cap. So where the scheme falls, or the scheme's increase rule falls within section 51.3, a scheme can set its own reference date at which to measure RPI rather than the overriding 30th of September date under section 51.2 and section 54. As we understand it, the claimant's case is that this scheme and Rules C.2 fell within section 51.3 in relation to every annual increase unless and until the claimant exercised its power to impose a lower rate than RPI with a 5% cap. Just pausing there, just remind you that the wording of Rule C.2, I'm not going to take you to it unless you ask me to, does provide for what we say is the default rate of RPI with a 5% cap, but measured at the 31st of May. So on any view, we say it must have been intended that this was a rule that would fit you into 51.3, because otherwise you wouldn't be allowed to have at a different reference date. So let's just analyse briefly how this fits, how the claimant's interpretation of this rule and the scheme fit within section 51. Starting point, the claimant says, unless and until it exercises its power to reduce the rate, Rule C.2 would comply with section 51.3. So, in other words, as long as increases were in fact applied annually at RPI with a 5% cap, or perhaps a higher rate, that's enough. We get within the exemption. Now, as you know, we don't accept that, but even if the claimant is right, we say the regime would not have a reasonable or practical effect. We've set out in short the reasons why we say that in our skeleton at the paragraph 56, but by way of a fairly short example I had. If one imagines in year one, let's ignore prorating for present purposes, but in year one, the power that the claimant says it has to reduce that rate was not exercised. Increases were applied on the 1st of October, this would be the 1st of October 2003, based on RPI for the 12 months from the 1st of June 2002 to the 31st of May 2003, because that's the scheme's reference period. All is fine, the trustees have a few months to do the calculation, and that increase is applied. Year two, however, let us suppose that the claimant does exercise its power to lower the rate below RPI. I think on any view, and the claimant would accept this, the rule no longer fits within section 51.3, the exemption doesn't apply, so one is dealing with the overriding provisions of section 51.2. So this second year, the rate to be applied as at the 1st of October 2004 is the appropriate percentage, which is RPI for the 12 months to the 30th of September. As I said, it has to be to the 30th of September of the previous year because of the timing. So you have the period from the 1st of October 02 to the 30th of September 03. What that leads to is double counting. You have double counting of the RPI rate for an 8-month period from the 1st of October 02 to the 31st of May 03. You're going to have that period of RPI, so it's 2/3 of a whole year included in the calculation for both years 1 and 2. Year 3, let's suppose, getting to the end of this example, let's suppose the power isn't exercised again that year, in the sense that this mirrors what's in fact happened in the last few years. Your increases fall back within section 51.3 on the claimant's case. So your increases to be applied on the 1st of October 2005 in this third year revert back to those for RPI for the 12 months from the 1st of June 04 to the 31st of May 05. Now the result of that would be that the entirety of RPI for the period from October 03 to May 04, again an 8-month period, is simply not taken into account in any of the any of the scheme's annual increases. Now, the pension increase rule, Rule C.2, and indeed section 51, are clearly aimed, we say, at providing protection for pension members against the effects of inflation. And a construction of a pension increase rule that could lead to the double counting for significant periods of inflation and simply ignoring inflation for other significant periods cannot, we say, have been the intention. It could well distort significantly the pension increase to be applied. They could be artificially high, they could be artificially low, depending on what inflation was doing. But they certainly wouldn't, we say, lead to a reasonable or practical result. And just stepping back for a moment, one might ask, well, why would anyone want to do that? Why would anyone want to put in place a rule that could lead to that sort of result? It would be an administrative nightmare for the trustees, even on the claimant's case. It wouldn't provide any sort of reasonable protection against inflation for members. It's interesting also, one notes that Rule C.2.2, which is the other rule you're being asked to construe, which is the revaluation provision, expressly provides for statutory override under the Pension Schemes Act 1993 provisions. Rule C.2, by contrast, doesn't do that. And in our submission, that rather suggests that the intention was always that increases to pensions in payment could never be less than RPI, capped at 5%, so that this rule would never fall outside the Section 51(3) immunity, even if the power under the rule was exercised.
I mean, it's a very attractive argument, Mr. Bryan, but what I don't really understand is it's all in the power of the employer. So yes, if the employer exercises this power in a particular way, it can give rise to stupid outcomes. But I mean, it hardly tells you what the clause was intended to mean, because there could be stupid outcomes. So I mean, I don't see how it sort of adds the word higher. I see why it's cumbersome, but I don't see why it adds the word higher.
Well, my lord, it wouldn't just lead to potential stupid outcomes, but they're stupid outcomes which aren't things that the employer is then going to have to sort out. They're things that the trustee is then going to have to sort out. And one asks the question, well, what would the objective observer think in possession of all the background information, including the legislative background, was the intention behind this rule? We say, before we get to this point, that this is not a rule that is unambiguous and unambiguously means what Mr. Short says it means, viz. Any other rate whatsoever. So it requires some sort of limitation. And we say that this argument pushes you towards what that limitation is going to be. Because if, as we say, the intention could not have been that this was a rule that was intended to fit within Section 51(3) sometimes, and on other occasions not, we say it was obviously a rule that was intended always to fit within Section 51(3). Once you get to that point, the only way in which it could do that is if the power was limited such that it could not reduce the increased rate below the relevant rate as defined in Section 51(4). And that we say.
I mean, are you not just redrafting the contract, which is obviously not permissible, rather than, I mean, because there are other possibilities that would make it work, set a rate above 6% or whatever. I mean, there's any number of different formulations. So why should we choose the one that is maybe the simplest, but is not in the document?
Well, my lord, as I've already said under my previous key submission, we say, you may disagree, but we say that in this case, this rule does not have the meaning, and certainly not the unambiguous meaning, that Mr. Short contends for. Once it gets...
Sorry.
No, I was simply going to say, once one gets to that point, one is looking at the context in conjunction with the text. So textualism and contextualism working in tandem, and one is asking the question in essence, well, if the rule does not mean what the claimants intended to mean, well, what does it mean? What are the possible rivals? What one, I suppose, is Mr. Short's construction, any other rate whatsoever. One, we say, is ours, which does not permit a decrease in the rate. And the legislative background, I'm coming to the documentary background in a moment, but the legislative background, we say, pushes you in that direction.
Yes, thank you. The question I was going to ask you was this. We know that the DB schemes were closed to any new members. They were not closed to future accrual to transferring active members, were they? You could continue to accrue.
For the actives who consented, yes.
But, nevertheless, as at March 2003, which is the transfer date, that a considerable bulk of the liabilities, all pensioners and deferreds who left before April 97, plus the parts of the liabilities attributable to pre-97 service for everybody else, would not be subject to the statutory provisions in section 51. That's correct, isn't it?
My lord, would you just put that to me again? I may need to have a quick
well, let me just put it like this. Section 51 only applies to post-97 service, is that right?
Yes. Yes.
Yes. So any deferred or pensioner who left before April 97, which must be quite a significant proportion of liabilities when we looked at the figures earlier, plus all the bits of pension liability attributable to deferreds and pensioners and actives who were in service in April 97, but whose pension, those bits of their pension liabilities attributable to pre-April 97 service, are outside the statutory regime entirely.
Yes, I think that must be right.
So why, you say that your construction is the only construction which enables the appropriate percentage to be avoided, so that you only use the relevant percentage, but you could, this slightly bleeds into round two, but assuming that you could, as the employer, specify different rates for different tranches, there would be nothing to stop the employer saying for post-97 we'll stick with RPI 5% based on May. For pre-April 97, which is a substantial proportion of that, we want to revert to 4% LPI, which is what we had in the predecessor provisions, or we want to change it to 3% fixed, or 1% fixed, or whatever. None of that would have the undesirable consequences you pointed to of triggering section 51(2) and requiring the RPI to be based on the September date.
But my lord, one must remember Rules C.2, both in the staff and the executive sections, and I appreciate that there is a separate construction stroke rectification stroke, possibly estoppel, possibly other types of claim issue in relation to other bits of these rules. But on the face of it, these particular rules that you're being asked to construe only apply to the actives who transferred over.
Do they not apply to the deferreds and pensioners as well?
On the face of it, no. General Rule A4.
Oh, I'm sorry, I missed that point.
It's General Rule A4.
So is it?
Would it help to take you to the rule?
Yes, thank you.
Tab 4 in the supplementary bundle is probably the easiest place to find it. It starts at page 51. If you go to page 58, you can see the first section is the general rules. You have page 60, transferred member is defined as a beneficiary under the predecessor plan or the predecessor executive plan. That's the two plans, the six continents plans. Who is notified by the trustees who is notified to the trustees by the trustees of the predecessor plan or the predecessor executive plan with the agreement of the principal employer as a person whose benefits are to be transferred. So that's a definition of transfer plans. And then you have over the page, you have General Rule A4, transferred, deferred pensioners and pensioners. So this is the deferreds and the pensioners. Each person who is a transferred member and who under the predecessor rules and so on is either in receipt of a pension, entitled to a pension which hasn't started, excuse me, or contingently entitled to a pension or other benefit on the death of another person. So pensioners, deferreds and survivors is entitled under the plan to a pension of the same amount payable on the same terms as the pension to which he is entitled under the predecessor rules. or the predecessor executive rules. So
we're not concerned with deferreds and pensioners at all?
Not directly in terms of the construction of these particular rules, no.
And that's also the answer to the GN16 point, because the deferreds and pensioners did get exactly the same benefits under the previous rules, so there was no difference between the GN16 certificate.
Well, we don't know what the GN16 certificate says. We might surmise.
No, but if you're getting exactly the same benefits, then the GN16 certificate follows as a matter of course, doesn't it?
One might think so. One simply doesn't know because we don't know what was in it. One can surmise from what's in the transfer deeds and the relevant clauses that I'll come to in a moment if I have time. The relevant clauses which deal with, is clause 7, I think, deal with the intention to continue with discretionary increases in excess of 5%. That rather presupposes that increases up to 5% are guaranteed because they're not a discretionary matter, and it also that particular clause applies to all transferring members, deferreds, pensioners, and actives. So one might surmise from that the transfer credits were calculated and the GN16 certificate prepared on the basis that deferreds and pensions were all going to be entitled to guaranteed 5% LPI increases, but we don't have the certificate.
Thank you.
My Lord, I'll turn now to the documentary background. We went through most of it yesterday towards the end of the afternoon. I've already discussed the transactional background and the fact that the whole reason for establishing the plan in the first place, the Britvic plan, was to accept transferred members with associated assets and liabilities. So a number of types of document, dealing with them in chronological order, in effect. So the first two documents, I took you to them yesterday. They're at tabs 10 and 11 of the supplementary bundle, and I won't take you to them again unless you ask me to. These are documents that go to the genesis and aim of the transfer, the announcements explaining what's going to be happening and the basis for it and so on. Those, in my submission, I don't think there's any issue raised about this, but they're clearly admissible. They're not pre-contract negotiation documents. They are genesis and aim of transaction documents, and that comes out of any number of cases, Brennan, Simmons, Chartbrook, and so on. And this is where we first see, as far as we know from the evidence that's been disclosed, the replication or benefit structure representation being made, if I can put it that way. And as we saw yesterday, that then continues consistently throughout the entirety of the transaction documentation. And certainly for executive scheme members, that could not on any view include a power to reduce the increase rate on their pensions in payment. So I rely on those documents and the particular passages that I took you to yesterday, and I'm not going to repeat that now. The second set of documents are the documents that contain the transfer terms for active members who consented to the transfer. Again, I took you through these yesterday, so I won't do so again unless you ask me to. But what those documents do is, we say very clearly, they set out for active members of the two schemes what the terms were on which they were being invited to transfer to the new Britvic Pension Plan. And if they signed on the dotted line, as it were, either to transfer for future accrual only or to transfer their accrued benefits as well, that was the documentation that told them what the terms were on which that transfer would take effect. That, in our submission, is akin, once they've accepted the offer, as anyone who became subject to Rules C.2 by definition must have done, that is akin to the sort of antecedent agreement documentation of the sort discussed in cases like KPMG and Cherry Tree Investments, which we looked at yesterday. Coming to what the specific terms were, again, we've looked at them and I won't go through them in detail, but for example, tab 16 of the supplementary bundle is the version for the executive section. And we saw in my submission very clearly what it was that was being offered to the members and what they accepted. They were invited to choose whether to transfer at all, and if so, to include their accrued benefits. It was said in terms that the items enclosed with this letter, which included the summary of benefits, quotes, set out the terms under which the new scheme has offered to provide benefits in respect of past service in the case of the option form. The terms of the summary, which are said to include the terms on offer, are clear. Guaranteed increases of RPI capped at 5%, and that's what anyone who accepted this offer and consented to transfer was agreeing to. They didn't have anything else to go on. And that, we say, is what an objective observer would also have concluded were the terms on which members were consenting to transfer, and they would then be the terms that were reflected in their Britvic plan membership, even if other details would be set out in the deed and rules in due course. These, we say, were key parts of the overall transaction. And insofar as it's, as I understand it, said against me, well, look at the disclaimer, it's a bit like a scheme booklet, you can't rely on scheme booklets. But my submission that these are documents of a wholly different character. A scheme booklet generally is simply explaining in summary terms what the terms of an existing scheme are. It's doing so in the context of a scheme where the actual rules are already in existence. There's usually a disclaimer saying the rules will take precedence, and if anyone wants to see a copy, then contact the trustees. That is very much not this case. This is a case where the offer terms being sent to the members were specifically telling them the terms on which they could choose to transfer. They were, in essence, a specification document setting out the terms that would then be included in the rules when drafted and executed. So those, we say, are in effect antecedent agreements to which some considerable weight should be given. And this then ties in with what, with the benefit provision that is then implemented in the scheme itself. If I can go back to tab 4.
Just before we leave that,
Yes.
can we see precisely how it is you put that? I mean, are you saying that there was an antecedent agreement that became a term of contract? I mean, that's not really what we're concerned with. This is pure matter of construction, isn't it?
But my lord, yes, but it's what the submission is. The submission does not need to rely on a formally binding contract as such. What it relies on is, in essence, a formal offer of terms is made, terms of the transfer. That is accepted by the members. Whether that forms any sort of formal legally binding relationship may be a matter for another case, but it's not a matter for this case. But what we do say is that there was a clear intention to form legal relations of some sort, and that then informs the proper construction of the rules that are then implemented. And I was about to take you to the specific rules. It's tab 4 in the supplementary bundle. Just to finish on this point, page 128, please, is the example from the executive rules, but there's as the equivalent in the staff rules as well. You have section C, starts at the top of page 128, calculation of executive DB member benefits, the usual sort of provisions for retirement at NRD, late retirement, early retirement, and so on, ill health retirement. And we can see, for example, at C11, pension is calculated by reference to capital as scale pension. And if one goes back to page 122, the definitions include scale pension. As we saw yesterday, it's a slightly complicated accrual choices under the executive rules, but in each case, it's accrual by reference to pensionable employment in capitals, and then if you go back another page, that is defined as an executive DB member's last or any period of plan membership if an executive DB member is a transferred member, which I think by definition they all would have been. It includes the executive DB member's period of pensionable employment under the predecessor plan or the predecessor executive plan. So for those members to whom Rule C.2 and indeed Rule C.2 applies, it applies to all of their pensionable service, both pre and post inception of the Britvic plan. And in my submission, it is hard to see any other conclusion in that context other than that the Rule C.2 is intended to provide for guaranteed increases to which, on any view, the executive plan members were entitled for past accrual. And as I've said, if your lordships are against me on finding that conclusion by the route of standard construction of the words used, then in my submission, it must be clear that there's been a mistake in the wording, and it's equally clear what the nature of the mistake is, because otherwise this the rule simply cannot work, at least for executive plan members, and as I said yesterday, it is accepted by all that the rules mean the same thing for both sections and in all iterations. Before I leave the documents, and with more than half an eye to the time, I need to say something brief about the transfer deeds. Now, I don't want to spend an inordinate amount of time on this point, but it is a point that's raised against me, so I'll deal with it briefly. We hadn't understood that there was an admissibility issue on this appeal until I think it was Sunday afternoon when Mr. Short kindly sent us a copy of the case on Heck Gardner case. And as I've already said, the transfer deeds are clearly admissible when construing the 2007 version of the rules. So they're part of the background for that. But let me deal as briefly as I can with the specific admissibility point that's made against me. We say that the transfer deeds, and just to remind you, they are at supplementary bundle tabs 5 and 6. 5 is the pension plan, 6 is the executive pension plan version, and the particular clause that Mr. Short took you through that I've referred to already this morning is at page 153 in the first plan, and at the bottom of 171 in the second is the discretionary practices point. And I've already made the point that it is a necessary inference from that any increases below 5% were, or up to 5% were guaranteed. We say those deeds, albeit dated after the 2003 rules were executed, albeit before the 2003 rules come into force a few days later, they're all part of the same transaction, and as such they are admissible when construing the 2003 rules, insofar as it's necessary to consider them for these purposes. Mr. Shaw relies on the case, specifically paragraph 13. A separate copy has been sent to you, it's not in the authorities bundle. I ask you simply to note the comment from Lord Justice Lewison in paragraph 13, which Mr. Shaw relies on, is obiter, and it expressly acknowledges that there had been no argument on the point, so one might say, with the greatest of respect, it's not particularly strong obiter. We provided to you, and I hope they've reached you, copies of two further documents in response to Mr. Short's new case. One was an extract from Lewison on the interpretation of contracts, and the other is a copy of Smith and Chadwick, which is the case referred to in paragraph 13 of the Coulson case. It's not clear whether the Coulson case was raised here in light of Sir Kim's reference to it, paragraph 3.09 of the extract from his book that we've provided to you, but I'd simply invite you to, insofar as it's necessary, read that paragraph, reread paragraph 13 of his judgment, and we say that it's rather hard to see how his obiter comments provide authority for the statement he then puts in his book. The two don't seem to us to marry. In any event...
sorry, which paragraph? I'm sorry to interrupt you.
Not at all. It's paragraph 3.09. It's section 3 from chapter 3.
Yeah. 3.09, which starts, however, in such a case.
No, it's slightly oddly formatted. 3.09, the number is at the bottom of the first substantive page of the extract. The paragraph in question is over the page.
I see. Thank you. Sorry, that's why I couldn't follow it. The numbering is. My
apologies. It's
no, confusing. Fine. Thank you.
I tried a variety of ways of reformatting it, and none of them seem to work. And footnote 20 is the only references to Coulson. So where we get to is the Coulson case itself is not authority, we say, for anything of relevance to this case. On the facts of the Coulson case, there were two contracts, two agreements. Not all of the parties to the first agreement were parties to the second agreement. If you want to think of it in terms of Venn diagrams, there was a bit of overlap, but the circles didn't overlap completely, or one was not a subset of the other. There were two separate circles with a bit of overlap in the middle. If one actually goes back to the case that is relied on in Coulson, Smith and Chadwick, again, we've provided you with a copy. For reasons of time, I'm not going to read the relevant passages out aloud. I simply invite you, it's the bottom of page 61 in the report, the paragraph towards the bottom of that page, which gives you a bit of context, and then the substance of the judgment of the Master of the Rolls is on pages 62 and the very top of 63. And what the case was concerned with, it was only part of the case, but it was there was a company prospectus that had been sent to the plaintiff, as he then was. He bought shares, he said, on the basis of that prospectus. Sometime later, he was sent a circular which said, in his case, rather different things about the company, and which then prompted this part of the claim. And he said the later document was admissible when construing the earlier one. The trial judge agreed with him, and the Court of Appeal overturned that. And the key points coming out of the Master of the Rolls judgment in my submission are top of page 63. The two documents don't have to be contemporaneous. As long as they are, as long as they are a series of deeds representing a single transaction between the parties, then that's enough. There is a point about having different draftsmen. That doesn't apply here. We know all the deeds are drafted by Allen and Overy in standard form, as I understand it. What we also didn't have in Smith and Chadwick was all of the defendants who were parties to the first document being parties to the second. And the result was that it was held that the documents didn't emanate from the same mind. That doesn't apply here in my submission. The parties to the 2003 Deed of Rules were parties to both of the transfer deeds. It's right, as Mr. Short has said, there were two additional parties, the principal employer and trustee of the predecessor schemes in each case, but same individuals same parties were party to the transfer deeds, and indeed the same individuals signed both. So if one is looking for emanations from the same mind, one clearly has that in this case. and further support, I say, comes from the Cherry Tree Investments case, Lady Justice Arden dissenting in the result, but not on this particular point. And she said at paragraphs 80 to 81, 81 in particular, again relying on Smith and Chadwick, the background referred to in those principles is plainly to be interpreted as including other documents executed as part of the same transaction, whether they happen to be executed before, at the same time as, or after the document requiring to be interpreted. So I suppose in short, it's not a question of timing, as the extract from Lord Justice Lewison's book suggests. It's a question of whether they are properly considered part of the same transaction, and in this case we say they are. The whole point of the Britvic plan was to receive the transfers effected by the transfer deeds drafted by the same people, parties to the first included as parties in the second, executed by the same individuals, and so on. It's all part of the same piece, and in those circumstances we invite you to find, insofar as it's necessary, that the transfer deeds are admissible when construing the 2003 deed and rules. But we say our case is sufficiently strong even without them. And if one is looking at them, as I say, it's clause 7, clause 7.1 in particular, which applies to all transferred members, actives, deferreds and pensioners, and it, I think, necessarily implies that discretionary increases over 5%, anything up to 5%, guaranteed. And that, we say, is entirely consistent with our construction and with our two-stage mechanism, which found favour with the judge. First part guaranteed, second part discretionary. The final point I want to come to in my submissions is the point raised in the respondent's notice. If necessary, which the judge found it wasn't, and we invite you also to find, we rely on this further point. We've already touched on the LPI legislation, section 51 in particular, in the context of our arguments on reasonable and practical construction, but that submission was based on what we say was is the claimant's incorrect interpretation of what section 51.3 actually means. We say that's not right, and insofar as the judge may have found otherwise, I have to accept that that particular passage of his judgment is perhaps not as clear as it could, with hindsight, have been made. We suggest respectively that he's wrong. This is the point in our respondent's notice, and I say again here, this point, as the previous point on the LPI legislation, goes as much for the 96 rules or in any pre-2003 rules as it does for the various iterations of the Britvic Plan rules. So if I can invite you to go back to tab 36 of the authorities bundle, I can deal with this rather more speedily than our last trip. We are concerned, as we've already discussed, we've been through the regime, the overriding provision of 51.2, the provisions of 51.3, which disapplies 51.2 in certain circumstances, and the key passage of 51.3 is that subsection 2 does not apply to a pension under an occupational pension scheme if the rules of the scheme require the annual rate of the pension to be increased at least annually and at least by 5% capped RPI. That's the relevant percentage. So the key question here in our submission is whether the rules of this scheme required at least annual increases by RPI capped at 5%. And the point, going back to 96, 97, when the LPI legislation came in this form, schemes had a choice. Either you had your own increase rule, which required at least annual increases of RPI capped at 5%, in which case you could set your own reference date for measuring RPI, such as the 31st of May, or you had no such rule requiring such increases, in which case you'd have section 51.2 imposing the appropriate percentage, RPI capped at 5%, pegged to the 30th of September in each year. So one looks at Rule C.2. Again, I won't take you to it unless you ask me to. We've looked at it a number of times. One has RPI capped at 5% with RPI measured at the 31st of May. And then we have the bracketed wording or any other rate decided by the principal employer. Now, let's analyse how that fits within section 51. The claimant says it's fine because it fits within 51.3 unless and until we exercise the power to reduce the rate. In our submission, that can't be right, because you can't have a rule which you say, on your interpretation, entitles you to pick whatever rate you like at whenever you like, i.e. an absolute discretion as to the rate, and yet still say that fits within section 51.3. One asks the question, well, did the rules of this scheme require increases of at least a relevant percentage? And in our submission on the claimant's construction of Rule C.2, they clearly didn't, because increases might well have been at a lower rate in any given year if the claimant chose to impose a lower rate. Required in section 51.3 must, in our submission, focus on the rules and what the rules were capable of doing, not simply what was happening in fact. And it's no answer in my submission, as I think Mr. Short suggested yesterday, to say, well, every scheme has an amendment power. Well, that may well be right, but the ability to change the rules in our submission is very different from having a rule that, in the claimant's case, gives them absolute discretion as to what the rate is going to be in any year. That in essence, is the nub of our respondent's notice point. I'm just going to touch on a couple of other things before I finish. And although Mr. Short rather soft-pedalled these points and submissions yesterday, he does rely in his skeleton argument, it's paragraph 52 for your note, on the Kinetic case and Arcadia. And I think he says these mean that our construction and our section 51 point doesn't work for some reason. In very short, we say Kinetic and Arcadia are clearly distinguishable because they were a different type of increase provision. They were concerned with a rule requiring increases in accordance with, and then a defined term, I think it was index in Kinetic, and perhaps rather curiously, retail prices index in Arcadia, which didn't necessarily mean retail prices index as we understand it. But in each case, there was a power to substitute a different index. So on that they were not cases where it was suggested that there was total discretion over the rate, where the employer could choose anything it liked at any time, whether or not it related to a recognised index. So we say they're clearly distinguishable, so that doesn't get us very far. But in any event, if one actually looks at Kinetic, for example, Mr. Justice Voss, as he then was, held that the rules meant, in effect, that pensioners had an entitlement to a future increase at a rate that was still to be determined by the trustee. It was a sort of A or B case, to adopt the Court of Appeals language from, I think it was the Safeway case, possibly Bernardo's. So here, if one applies the same approach, even if I'm wrong about these cases being distinguishable, you have a pensioner member who is entitled under Rule C.2 to future increases at the defined rate or any other rate that the claimant may decide. And coming back to section 51.3, on that basis, can it be said that the rules require increases of at least RPI capped at 5%? And the answer, we say, on the claimant's construction must be obviously not. It doesn't require increases at any particular rate at all. So Kinetic, we say, Kinetic and Arcadia don't help the appellant. They, if anything, they go the other way. And insofar as it might be said, well, Your section 51.3 argument is something that might have been available to the parties in those cases, even though they were concerned with section 67 arguments. The answer is simply, well, that they don't appear to have been argued, as the claimant acknowledges, and that doesn't really take us any further. And I suppose one might say, the risk of being accused of being flippant, well, the fact it wasn't argued in another case doesn't make it a bad argument in this case. So in my submission, and just finishing, where that leaves us, we say is that the Britvic plan at inception, and when rules are readopted on later occasions, did have a pension increase rule. It must have been intended to comply with section 51.3, and I've already made the submission that under the reasonable and practicable argument that helps us. But if we're right about the construction of what required means in section 51.3, one asks the question, well, why on earth would a scheme take neither well, we won't have an increase rule at all, we'll just rely on statutory increases, or we'll have a rule that is always going to be guaranteed to comply with section 51.3. Why on earth would they have a rule that might or might not comply? The result, excuse me, would be, as my Lord Justice Nugee touched on yesterday, I think the trustees would have to perform two sets of calculations every year, one under the scheme rule, one under section 51.2, using different reference dates, and then apply whichever gave the higher rate. That would be an administrative nightmare, to say the least. And we say the only way in which the increase rule in Rule C.2 in its various iterations could properly fall within section 51.3 and be guaranteed not to fall out of it is if it has the meaning suggested by the representative beneficiary. And whether one gets to this through standard construction principles, if I can call them that, or corrective construction, we say the result is the same. As I said at the start of this morning, I'm not proposing, unless you invite me to deal with the subsidiary questions. Our submissions are set out, I think, in sufficient detail in our skeleton argument. And unless there's anything specific I can help your lordships with, that I think is more than enough from me.
Well, Mr. Bryant, I mean, the fact, I mean, you make a very compelling case that it's an administrative nightmare, this rule. And you ask rhetorically, why would one have such a rule? The answer to that is because it was there before and nobody thought about it, most certainly, properly. But why does that mean that it comes within the corrective construction rule? We've had overnight from Mr. Short a note, which I'm sure you've seen, which demonstrates, anyway to me, that the type of corrective construction is where there is only one correction, and that suggests itself quite clearly either from extraneous material, which is obviously in everybody's minds, and demonstrates that it was obviously intended that to the objective observer that this was what the words meant. Now here, it's almost equally obvious that this was not grappled with because of if only because of your executive plan, which seems to me a very strong one. And my question really is, how does that get you home on the strict rules enunciated in Bernardo's and Safeways and so on, to the addition of a simple word, which is obviously incredibly sensible and probably what they would have thought if they'd thought about it properly, but they didn't. And what I don't see is how that comes now within the law as enunciated by the Supreme Court. I mean, I'm incredibly willing to be persuaded, Mr. Bryant, as the judge was, because it's what you say makes obvious common sense. But do you see my problem, and how do you answer it?
Well, I understand the point you're making, my lord. The phraseology your lordship has just been using sounds rather as though one is, well, the point you were making was what one interpretation is nobody thought about this. I don't accept that's necessarily right, but that's the sort of language one might use in relation to a rectification application where post Lord Justice Leggett's decision in FSHC, as he then was, we are, I think, reasonably well established that it's a subjective question, a subjective intention. We're not dealing with that. We're dealing with objective intention. And in that context, one simply looks at what the objective observer would have understood the intention was. And in those circumstances, in my submission, as you rightly say, I do rely on the executive pension plan point, but I also rely on all of the other ancillary evidence. And your question, my lord, was predicated on looking at a corrective construction route, as in adding a word. And if one is looking at it in that sense, one asks the question in line with the authorities, many of which Mr. Short has included in his helpful note. Was there a mistake? And if so, is it clear what it was? And in my submission, when one looks at not just the legislative background, but one looks at the documentary background and the documentation concerning this transaction, and as I've said, the whole basis on which the Britvic plan was being introduced was to accept the transfer. It was all part of the same transaction, this point I've already made. But if one looks at the totality of the evidence, I say it is abundantly clear, and would have been abundantly clear to the objective observer, that it was always intended that members should be entitled to guaranteed RPI capped at 5% increases, and anything above that would be discretionary. That's where the discretion comes in. There being no intention, again I say obviously, to allow the employer to reduce the rate for all the reasons I've set out. Not only would it have created this chaotic administration for the trustees, but it would have been entirely contrary to all of the expressions of what the intention was in the transactional documentation. The genesis and aims, the documentation being provided to the members, and insofar as admissible, the transfer deeds. It's all saying the same thing. It's all saying the intention is to have guaranteed 5% LPI increases. That, we say, gives the court and gave His Honour Judge Hodge more than enough, insofar as it's necessary to get to this stage, to say, well, insofar as Rule C.2 doesn't do that, and I can't construe the actual words to enable me to construe it in the way that we contend, it does give one more than enough to say there was obviously a mistake here. This was never the intention. Can I see how the rule could be corrected to reflect the intention? Answer, as Lord Justice Nugee did in the certificate insurance case, yes, I just need to put an extra word in. However one formulates it, there may be all sorts of ways of formulating it. The judge below added the word higher. As I said, there may be other ways of formulating it, but that will do as well as any. I hope that answers your question.
Yeah, thank you. So, anything from Lord Justice Coulson or Lord Justice Nugee?
Yes, I've just got one question, Mr. Bryan. We've obviously looked at a lot of the background material, and I understand the submissions that you've made, particularly about the letters. But is this right? As a matter of fact, there is no material that we have seen in which this power, the power in brackets, or any other rate decided by the principal employer, is actually separately considered or discussed?
My Lord, two answers, if I may. One is to the precise question, which is, as far as I am aware, there is no specific reference to a power which includes the words or any other rate. There's no specific reference to that wording as such. But in terms of, is there reference to a power to do anything other than award increases at RPI capped at 5%, then the answer is yes. I've already taken you this morning to clause 7.1 of the 2 transfer deeds, which deals with the discretion, and also if your lordship.
Oh, yeah, no, sorry to interrupt. You don't need to look at those. No, I completely understand that. My question, whether there was any separate consideration of the words that are at the heart of this dispute as to interpretation of the pension plan.
My Lord, as far as I'm aware, the reference, I was just about to take you to the summary at tab 16 of the supplementary bundle. Again, we've looked at it already. It's the guaranteed increases heading discretionary increases. That's, I think, as close as we get to a specific reference to a separate panel.
All right. Thank you very much.
I had one question, Mr. Bryant. I reminded myself of your skeleton on grants 2 to 5. Can I just ask you about grant 2, which is tranches point? What you say in your skeleton is the rationale of paragraphs 38 to 42 mean you should arrive at a single composite rate. I just wondered if you could explain that, because I didn't myself see it leap out from paragraphs 38 to 42, why there had to be a single rate as opposed to a tranched rate.
Two points, if I may. One is, we know that in 2008 the rule was expressly amended to reduce the cap from 5% to 2.5% for accrual from the 1st of July 2008, and you have the amending deed in the bundle. But only in that respect. And the first question one might ask is, well, why was it necessary to make an express amendment to that effect with all the cost and hassle that goes with formal amendments to the scheme rules, if the claimant is right that they already have the power to do that anyway? The second point in my submission is that we say that the way in which Rule C.2 is drafted, we say clearly envisages a single composite increase rate as a result of our two-stage mechanism, which is where we go back to paragraph 38 and following, I think it is about skeleton argument. In each year, there's no hint, we say, in the rule that there was any intention that you could subdivide the period of accrual and apply different rates for different periods, or point you picked up yesterday, my lord, apply different rates for different people. That's the nub of the point on ground 2.
I mean, I think that the case you're facing is that you just use Section 61 of the Law of Property Act to say rate or rates, and there's absolutely no reason why, whatever the answer to question 1, there is a discretion in the employer, whether it's an up or down discretion or solely an up discretion, and that the employer might want to rebalance historic injustices or discriminate between different tranches of service, and there was no good reason why that shouldn't be done. I mean, suppose, for example, there'd been a period of inflation. I know it's not actually the case, but there'd been a sustained period of inflation where RPI was higher than 5%, but the 5% cap had applied. And the employer, because of good investment performance larger surplus in the scheme than expected on the technical provisions basis, and might wish to use its power to benefit those people who missed out in that respect, without benefiting everybody, where other people hadn't missed out because they hadn't been in service during that period of time.
Well, I see the force in the point you make, my lord. We say, it's perhaps one of those interesting issues where it's rather difficult to identify precisely where the actual representative beneficiary's interests may lie, but it's an issue-based representation order, and this is the side of the argument we've been invited to argue. But we do say, and as I say, I see the force of the point you make, but we do say that irrespective of adding S's under the 1925 Act, the reading Rule C.10 as a whole envisages, we say, a single annual increase on that part of the pension which exceeds the GMPs. And the other point we can make is that if the employer feels that particular members have been hard done by and others haven't as a result of whatever it may be, inflationary quirks, then there's always the augmentation power.
Also the augmentation power. Yes. Thank you very much. I don't have any other questions.
Mr. Bryant, if you have no further submissions, we'll break there and we'll resume at 3 minutes past 12.
Thank you, my lord.
I think you might be muted.
Yes, I'm afraid I am. I think we've got everybody. Mr. Chu.
My Lord, I have one substantive submission and then submissions on certain factual points that have arisen as a result of questions from your Lordships over the course of yesterday. Before I turn to the substantive submission, may I check whether or not an extract from the executive plan has made its way to you this morning? That's 1988 executive plan.
Yes.
Yes.
I will come to that in due course, but I wanted to allow time, if possible, for that to get there if it hadn't. Turning to my substantive point, of course, the trustee is neutral on the outcome of this appeal, but this relates to a matter of administrative workability of the increase rule itself. And the point goes to the interrelationship between grounds 1 and 4 of the appeal. Ground 1 being the higher or lower declaration sought, and ground 4 being the set a rate at 0 declaration sought. The short point is this: if the company has the power to set a lower rate, but not to set a 0 rate, particularly in circumstances where inflation is positive, the trustee, and indeed the company and the members as well, need to have a workable scheme, the exercise of the increased power. If I may put it colloquially, it becomes a question of how low can you go. Now, Mr. Short accepted yesterday that a declaration of near to 0 was an inappropriate declaration to make because it was unworkable. But all that has done in my submission is change the issue from being one that is patent on the face of the declaration sought to one which is latent, because the same substantive point arises. And it arises in the following way. The representative beneficiaries argument on ground 4, paragraph 75 of the skeleton, which Mr. Bryant has not touched on, understandably for reasons of time, at page 68 of the core bundle, is that 0 increases should not be allowed, because that's not an increase, particularly in a situation where there's positive inflation. I paraphrase his argument badly. But that leaves the trustee with the following difficulty. If we take an example of inflation running at 2%, and an increase has to mean an increase in those circumstances, can the company validly set a rate of increase of 1%? If it can, what about 0.1%? And if it can, what about 0.01%? If this matter isn't resolved as a matter of construction today, all that happens is the goalposts get moved, and the trustee is faced with having to determine questions of validity on an annual basis, depending on the level that's set. So, my lords, that is the issue of workability that concerns the trustee. What are the consequences of that issue for the interpretive exercise which my lords are embarking upon? And I have 3 points on this. The first point is that the interrelation between grounds 1 and 4 of the appeal is relevant to the overall question of construction of the rule itself. One ought to be, in my submission, taking this point into account and giving reasonable and practical effect to the scheme. This is practicality in the courage sense Mr. Short put it yesterday. I'm taking this from the wording of the rule itself. It's not a question of practicality extrinsic from the document. And my submission is that the proper construction of the increase rule, in order to give practical effect, is one that clearly delineates the boundaries of the power, such that the scope of it is known and the trustee can properly administer the plan. As I say, if it's otherwise, all this decision will do is move the goalposts to what happens when a further instruction is issued. And removing near from the declaration sought does not solve that. The issue remains latent. Following on from that, the second point is that as part of the iterative process of construction, I invite your lords to test the approaches to ground 1 and ground 4 against each other. Because of this interaction, one needs to think about how the two operate together. The practical consequence of this is that therefore, on ground 1, construing simply the words in brackets, which have been the principal focus of the main submissions before you, but also how that fits together with the reference to increase, particularly in Rules C.2, but also in C.10.1. Thirdly and finally, on that point of construction, one solution, and it's a solution that's urged on you from both sides, is that grounds 1 and 4 and all 4 together. If either the representative beneficiary or the company succeed on both points, this administrative problem, the trustee, falls away. But if one takes that approach, it's incumbent on the company to explain why a rule that has in terms pension increases in 10.1 and the rate of increase in 10.2 can be 0 where there's positive inflation, particularly when the rate of 0 is not something getting bigger. Now, Mr. Short made short submissions on that yesterday in relation to ground 4. My point is simply that that feeds back into the question of interpretation of the brackets. So, my lords, that is my point on the substantive question of construction. I then have the, absent any questions on that, I then have the potpourri of trustees' points, if you like, on factual matters that have arisen over the course of the appeal, and I propose to take these in chronological order on the underlying history of what's happened. So if I may start firstly with the 1988 main plan rules. This was the first extract that we were sent to yesterday. My lords were referred to the increase rule itself. I ought to just show your lordships the increase, the index power that the trustees have. So page 2 of the PDF.
Sorry, which page are you on?
This is the first extract from the main plan that was sent yesterday.
Which bundle are you in?
It's not in the bundle because it was sent out.
Oh, sorry.
It's the 1998 extract of the main plan, so it's the first extract, my lord. The one we looked at yesterday briefly.
Is this the BAS executive pension?
No, it's the BAS main plan, not the executive plan. I'll come to the executive plan in a minute.
No, well, I haven't got that.
Can you identify the time and date of the email sending it?
Yes, my lord. If I can make points on the executive, if my lord the Master of the Rolls has the executive plan,
we ought to have the document. Is it the BAS Employers Security Plan?
That's the one. Yes, that's the one.
9th of August 89. I have got that. We got it yesterday, I think.
Yes, that's the one.
Okay, now can you tell my lord when it was sent?
Is it Wednesday at 12:08, 12:04?
Yes.
Thank you.
Yes, I got it at 12:06.
That's sufficiently close in time for me to be confident the court is all looking at the same document, my lord.
I think it is, but I feel left out.
It depends on the efficiency of your clerk.
Keep going, Mr. Chew.
I'm grateful, my lord. My lord, we looked yesterday at the 3rd page of the PDF, which had the increase rule in the 2nd paragraph of Rule 20, which is the percentage shall be either the percentage increase, if any, in the official index of retail prices, or if less, 4%.
Sorry, I'm just finding difficulty finding that. I didn't highlight it, I think. It's in paragraph 20. Is it, you say the 3rd paragraph, but there are 2 unnumbered paragraphs, and then it's A, B, C, right?
It's the 2nd unnumbered paragraph.
Oh, okay.
Down the bottom, it's the 3rd page of 4.
Correct. So page 3 of the PDF, the 2nd unnumbered paragraph starting the percentage.
Yeah. Okay, got it.
So that's the increase rule itself, which is the official index of retail prices.
Mm-hmm.
Now, there's no power there. If we go up to page 2 of the PDF, This is an extract from the definitions, and we see towards the top of the page is the third underlined definition, official index of retail prices. Do my lords have that?
Yeah.
We see here the power of the trustee to select an alternative index, because the rule says the index of retail prices published, etc., or any other index selected by the trustees. So the pre-96 position was that the trustees had an index selection power rather than there being an apparent company power to select a rate.
Yes.
Next in time, my Lord Justice Nugee yesterday raised the question of going from 4% LPI to 5% LPI. That happened in 1992, and we can see that in the extract of the executive plan that was sent round this morning. That's the latest PDF that's gone around, and it's on page 2 of that document, which is useful. So it's the second unnumbered paragraph under Rule 20 on page 2. And if my lords have it, they will see the last 3 lines of that paragraph say, or if less, 4% for any increase made before 1st October 1992, and 5% for any increase made on or after 1st October 1992.
Yep.
And just to give some context to that, and this was in the Mitchells and Butler's proceedings pleadings that were in evidence below, what happened was in 1992, there was an apportionment of surplus between the members and BATS, then the company. This led to a reduced contribution rate for BATS for a period and an increase in benefits for members, principally this 45% increase, but also, as it happened, the sorts of inflationary catch-up increases that my Lord Justice Nugee referred to a short while ago. So this change to 5% wasn't responsive to the upcoming Pensions Act 1995 amendments. Point 3, the defined benefit sections are closed to new members for all practical purposes. And if I can just give you, my lords, the references to those pages, you see from the background to the Britvic 2003 deed at page 55 of tab 4 of the supplemental bundle that membership was to be for those who had been contributing participants in the predecessor plans. And that is followed through in the definition of member in the defined benefit sections at page 98 of the supplemental bundle behind, say, tab 4. That definition of membership did allow the employer to invite other members to join, but in practice it was being run as sections that were closed to new joiners, and you see that principally from the letters that were sent out to members at tab 15, page 248, and particularly the option form that the executive plan members selected, that's supplemental tab 16, page 257. My Lord Justice Nugee raised the question about ongoing accrual. There was ongoing accrual under the DB sections until 2011. That's paragraph 27 of Mr. Wiley's witness statement, supplemental 18, page 296. Point 4, the bulk transfer GN16 issue, I don't understand that to be live anymore following the discussion between my Lord and Mr. Bryan this morning about the role of the deferred and pensioners. That's gone. Point 5, my Lord, the Master of the Rolls, identified issues around paragraph 133 of the judgment where His Honour Judge Hodge referred to being highly sensitive to the facts of the present case. And it's important in my submission to see that in the context of what the judge says at paragraphs 118 and 119, where he talks about exactly what it was he was deciding, as page 100 of the core bundle. Electronically, and it's page 90. I did page 100, I apologise. So paragraphs 117 and 118 at 100Y1, the judge talks about the limitations of his decision and that he's not deciding questions of construction of fast deeds. And so it may well be in that context he's talking about being cautious about being highly sensitive to the facts of the present case because he was conscious that he didn't have all the material before him and that the Mitchells and Butlers proceedings were ongoing. I just raise that because it's a turn of phrase that has been the subject of some submissions. Point 6, the rates of inflation and the instructions that have been given. For May 2020, RPI was 1%, and so that is equivalent to the instruction for 1% increases that was given in 2019. CPI at that date was 0.5%. I think Mr. Short yesterday said there wasn't much in it. That was certainly true as between a 1% instruction, 1% RPI. But where RPI is 1% and CPI 0.5, that's not quite accurate in my submission. And contrast the context of the 2019 instruction, which is at page 342 of the supplemental bundle behind tab 20. RPI was 3%, CPI was 2.4%, and the instruction was for 1%.
With the practical effect that section 51 would mean you had to award 3% to post 97 accruals anyway.
It would have been, if I can take you to the instruction, my lord, you can see how it's set out at 342 of the supplemental deed. And because this was 2019, it would be 2.5%.
Oh, I see. Yes.
Sorry, I didn't signal just how forward I was moving in time, I apologise.
Yes, I see. Thank you.
The table, my lord, at 342 sets out the different levels.
Yes.
My lord, just in response to the question about the upcoming Mitchells and Butlers proceedings, the court is now well aware that there are rectification and construction points being run in those cases. And as my lord, the Master of the Rolls said yesterday, it's just a case of getting on with it. But I do invite the court to be conscious of the scope of this appeal, not only the limited questions that are being put before it, but also that these proceedings have been brought under Part 8 with consequences for the extent of the material before it, particularly when one is faced with submissions based on the idea of replicating benefits. Of course, we know that the words carried over, but it does open up the questions of what those benefits were in substance, whether there is any equity of rectification, and also questions of construction, which are in dispute in those proceedings, but the court is alive to that. My Lord, my final submission is just on the question of the timing of any decision and its impact on any future pension increases. The trustee, in order to administratively be safe, must give an instruction to the plan administrators the level of pension increases to implement in around mid-August this year. So, whilst of course it will be a matter for your lordships, a decision, say at the very end of the term, would leave limited time to give effect to it. So I raise that so the court's aware of the future-facing impact of this appeal. My Lords, I hope I've dealt with the factual matters that have arisen over the course of the last day and a half. Otherwise, those are my submissions.
Thank you very much, Mr. Chu. Lord Justice Coulson? Lord Justice Nugee?
No, thank you.
Mr. Short?
My Lord, I'm grateful. I only have a small number of points, and I will go through them, I hope, quickly. The first is, your lordships have obviously received my note. I don't say it is not comprehensive. Well, it is not comprehensive, but it is as comprehensive as I was able to make it overnight. My second point is to make one observation in relation to the note. Doesn't strictly arise out of anything Mr. Bryant has said, but I hope it will be helpful. And that deals with the example of a case where a decimal point is missing. Now, in some cases, it might be apparent on the face of the document that that decimal point is missing, if, for example, the true figure appears elsewhere. But in many cases, it will only be apparent that a decimal point is missing because something worth £1,000 is being purchased for £100,000. And that does involve business common sense that would be within principles 4 and 5 of Lord Hoffman's speech in ICS. In a narrow sense, but one would still need to look outside the document to think, would someone really agree to pay £100,000 for this item? And in those circumstances, it would be possible to say, although it's not ambiguous, it is so plainly absurd, by reference to business common sense, that a mistake must have been made. My Lord, my third point deals with the preservation regulations, which my learned friend Mr. Bryant took you to yesterday. These are at tab 32 of the bundle of authorities. And in particular, Regulation 12, which deals with the transfer of accrued rights without consent. I'll deal with this quickly, but the reference to certificates and transfer credits is important where one is going from a scheme that provides one set of benefits into a scheme that provides a different set of benefits. The actuary really needs to say this is broadly comparable and works out what the value of the transfer credit is going to be. But it's not really appropriate where the member is being transferred to a scheme that is either retaining the rules expressly, such as in Rule A4 here, which says you are bound, or the member's benefits are still as set out in the rules of the predecessor schemes, and nor is it relevant where one has a mirror image scheme, so where the new scheme is set up to replicate the old. But more to the point, the reference that was made was to subparagraph 4b, which is the top of page 720, and this is information that is to be provided where it's proposed that the transfer is to be, where it's proposed that a transfer will take place. And from that, it's clear that the information is to be provided by the transferring scheme rather than the receiving scheme. And what A tells B is not a very sound basis for construing a contract between C and D. And that's why anything provided under this regulation would be very different from the summary of benefits, different in nature, irrespective of the content, than the summary of benefits provided by Britvic itself. And to clarify, I do want to make clear that I'm not making any positive assertions about any information that may have been provided by 6 continents to members who were being bulk transferred. And yesterday I was limited to saying there was none of that information in evidence before the court. The fourth point I have is this: it is true that anyone who was a pensioner or deferred in 2003 isn't governed by Rule 10.2 itself, but those with service after July 96 are governed by the 96 Bass Deed as amended, which, subject to the outcome of the M&B proceedings, includes the same power. And I took your lordships to that rule. That's for members of the staff section. And indeed, both they and those who left service before July 96 are indirectly affected by this question. One of my fifth point.
Can I just ask you, do we know why people with post-July 96 service were excluded from the transfer?
My lord, people with post-97, deferreds with post-97 service were excluded from the transfer because it was thought that there was a problem, a technical problem, in transferring people who had protected rights under the contracting out, EMP contracting out regime into the new scheme. And so it was done, can I say, for technical reasons that don't, I think, shine light upon this question. Thank you. My lords, my fifth point, I'm response to something my lord the Master of the Rolls said earlier, and it may well be that no one had considered carefully the meaning of the power, as in many of these cases, parties hadn't considered their increased powers in any detail until recent years. And that probably explains the BAS booklet and the summary of benefits rather than shedding light on the meaning of the power. Because these are all simply documents that set out what someone may have thought a rule meant rather than defining what that rule meant. And to perhaps put that in context, even in cases where there is a power to select a different index, there will be innumerable booklets that say your pension is guaranteed to increase by reference to RPI. And yet that wasn't the case. In fact, once statute changed so that either CPI automatically applied or because a trustee had a power to switch from RPI to CPI. But what in the past was thought to have been the meaning of a rule sheds very little light on what in fact that meaning was. My sixth point, my learned friend Mr. Chu's invitation, Rule 10.1 provides for increases, but properly understood, it provides for increases in accordance with Rule 10.2. And Rule 10.2, on any basis, can provide for increases of 0%. And that's why I say the suspicion that a 0% increase is permissible should be accepted. My seventh point is a short one. In relation to Smith and Chadwick, which was has been provided separately, it's not in the bundle of authorities. In fact, I invite the court to adopt the analysis of Lord Justice Lewison in the interpretation of contracts, because in fact, one looks at the bottom of page 62, and the top of page 63, it's apparent that the Master of the Rolls in that case held that the circular that was dated the 3rd of June was not admissible to construe the prospectus dated the 27th of May, and that the interval between those documents was important. My Lord, my penultimate point is this: the practical problems identified by by my learned friend, Mr. Bryant, don't arise if one can give different rates for different tranches of benefits, or if the employer doesn't do something silly and they do not compel a conclusion on construction which is at variance with the words. And my Lord, finally, yesterday, my Lord Justice Nugee asked me if I accepted whether the effect of the construction of section 51.3, which I contest, if that was right, whether it would mean people would get the better of the appropriate percentage and the relevant percentage. I equivocated and said there were some circumstances where that was not necessarily the case, and I decided to think of some examples overnight. I can't, and so I have to accept that I should have agreed more readily, my Lord Justice Nugee is correct, it would be the better of the two. But I say that provides a good reason not to construe the statute in a way that would have that inflationary ratcheting effect. And my Lord, unless I can assist further, those are my submissions. My Lord's on mute.
Sorry, I'm a repeat offender about that. Lord Justice Coulson.
Thank you very much.
Lord Justice Nugee.
Just one question. The question of construction we're actually grappling with is the question of construction of the 2007 trustee rules, I think, as amended in 2008.
My Lord, and the 2003 deed.
Yes. One of the points Mr. Bryant made was that whether or not the transfer deeds were admissible to construe the 2002 deed, they were undoubtedly in existence and therefore admissible to construe the 2007 deed.
Yes.
Deed. What's the answer to that?
Well, the answer, as a matter of substance, I say they don't do what he suggests they do. Secondly, that they are admissible strictly in that they're part of the background, but they're not admissible or they're not relevant because of the approach to be taken to construing unambiguous words. So I've rather garbled that they're not inadmissible because they post-date the 2007 deed, because obviously they don't. They're inadmissible because it's an unambiguous clause, and if they are admissible at all, they are of very little weight and they don't change the proper conclusion.
That I understand. But does that mean that the interesting debate as to whether they would have been admissible if what we were construing was the 2002 iteration is, for our purposes, academic, because whether they came as part of the same transaction or as a different transaction subsequently, we can look at them anyway when construing what we actually have to construe.
But it's not entirely academic, my Lord, because people who left 2000 before the date of the 2007 deed aren't subject to the 2007 deed. They're subject to the 2003 deed. So if there is a change in meaning, it would affect some but not others.
But we're not asked to construe the 2002.
My Lord, you are. I am, and I apologise if I haven't made that. But it's the same finding was made in relation to both.
I see. Okay, I'm sorry. Thank you. That's very helpful. Presumably, I mean, your thrust of your submissions is there's no reason to give them different constructions. They have the same words and they should be given the same meaning.
Yes. In fact, I think my learned friend himself submitted that everyone suggests they have the same.
Thank you. I don't have any other questions.
Well, thank you. Thanks to all of you for a very interesting argument. We will take time to consider our judgments, and when we've done so, we'll let you have them in draft, and we'll asking for textual corrections only, please, and then if you can agree a consequential order and the costs, that would be helpful. If you can't, we'll determine those matters in writing. But that concludes today's hearing. Thank you very much indeed.
Thank you, Madam.